I'm going to start. Hi, everyone. I'm sorry for the delay. We hope to have Mike with us very shortly. And in the interim, I will just start our interview process with our three guests. I'm Mary Kate. I am the communications consultant with Death Penalty Focus, and I'm here with Yoko, who is our associate director and is behind the curtain trying to work out a couple of our issues right now. But in the meantime, I would like to introduce you to three people that are better equipped than anyone I know to explain to all of us the potential ramifications of the California Supreme Court's recent order to Attorney General Rob Bonta. That order was in response to a 2024 lawsuit filed by a coalition of prominent civil rights groups and legal organizations that argued, quote, extensive empirical evidence demonstrates that California's capital punishment scheme is administered in a racially discriminatory manner and violates the equal protection provisions of the state constitution. In other words, the lawsuit claims the death penalty is applied unfairly, especially due to racial bias, and that this goes against the part of the state constitution that promises all people should be treated equally under the law. Our three guests were part of the litigation team that drafted the writ petition. Avram Frey, a lawyer with the Northern California ACLU. Jessica Oats, a lawyer with the Office of the State Public Defender. And Robert Bacon, a longtime death penalty lawyer with a long history with the state Supreme Court. We are thrilled to have all three of you with us today, and thank you very much for being here. Avi, I'd like to start with you if I could. The court told Bonta to show cause in Superior Court of California, County of Sacramento, why the relief prayed for should not be granted. Each party may advance any procedural or substantive arguments it believes are appropriate in support of or in opposition to the relief request. Can you give us a breakdown of the significance of the order and what the court wants to know before deciding whether it agrees that the state's capital punishment scheme violates the equal protection provisions of the state constitution? And were you surprised that the court wanted a response by June 26th, which seems like a quick response time? And it does sound as if this, I'm just adding myself, but it also sounds sort of as if the court agrees with the writ. Can you address all of that for me?
Thank you, Mary Kate. I can try. Um, so the first thing to say is I agree with you that this is a very good thing. Um, but I want to clarify that this is more closer to the start than the finish. And part of that depends on an understanding of writ practice in California and some of the formalities and peculiarities of writ practice. This was filed as a writ in the California Supreme Court in the first instance. It's called an extraordinary writ. And we filed it there because we believe that the facts are overwhelming in support of our claims and that this was a legal issue that was ultimately going to need to be decided by the California Supreme Court. So why proceed through the typical process in which there's fact finding at the Superior Court and it moves its way up and then ultimately calcifies the legal issues? So we said, here are some legal issues supported by abundant facts. The Attorney General has effectively said these facts seem likely to be true and they're highly problematic. So wouldn't it make sense for the California Supreme Court to jump in and end this unconstitutional stain on our, state criminal legal system? I would describe what the court has done as saying there's something there that needs to be investigated, but let's go through the orderly process and we're sending it back to the Superior Court in the first instance. In order to show cause by the formalities of that language says, show cause why we shouldn't grant this relief. That's true in every case in which there's an order to show cause. Court says, tell us why the petitioner doesn't win. That sounds very promising, But in fact, it's just a demand that the government respond and suggest the case will now proceed. Um, there are a couple of things to note about about the context and also about the particular order to show cause that I think suggest a little more. One is the court has said you can raise any procedural or substantive arguments. There has already been extensive briefing at the California Supreme Court. So the California Supreme Court did not decide some of the threshold legal questions about our challenge and said these two should go to the Superior Court for resolution below in the first instance. So in many ways, it functions sort of as a remand, what would be a remand in typical civil litigation, saying we're not deciding the merits issues. So that's sort of, and then the obvious reason to send it back down to the Superior Court in any case would be for factual development. You know, we cite a lot of studies that are based on very rigorous methodology, which overwhelmingly show the same thing, which is what I think people on this call will know is the death penalty is disproportionately applied in cases of Black defendants or people of color who are defendants and white victims. Um, but there is ample literature that we put before the court, and the court is saying, let's provide some degree of testing through the adversarial process. Maybe the attorney general will agree, maybe the attorney general won't agree, but let's have a fact finder and bring it back to us when it has that sort of imprimatur of, typical adjudication. All of that being said, which I think is maybe a reason to hit pause on the court has already decided in our favor,
Yeah.
the court could have ended this case. I mean, that's the big thing to know. The court did not have to issue an order to show cause. Most writ petitions do not garner an order to show cause, whatever the challenge is. And
Oh,
an extraordinary writ petition filed originally in the California Supreme Court stands a very, very poor chance of garnering an order to show cause. So it's quite significant that we've gotten as far as we have. The court is saying there's enough here to merit an adjudication. But they are saying we're not going to be the first ones to adjudicate it. And they are probably saying we'd like to see a bit more testing of these facts before we decide the ultimate legal issue. Because I think everyone agrees that ultimately the California Supreme Court is going to decide this issue again, just after it's gone through now this more typical adversarial process. Oh, and then the last point, sorry, Kate, the date, I mean, I love that they're under the gun, but that is also a formality. The response time is set by statute. And so, and they can also come back and say, we'd like a bit more time. And they don't need to, at this point, provide all of the factual proof in support of their claim. And we don't expect that they would be able to at this point. I think what's most likely in their return is they will repeat some of the procedural arguments that they made in the California Supreme Court, and maybe they'll propose a manner of resolution of some of the factual issues. But it is not quite what it seems, where, I mean, if you just read the language and didn't know the context of order to show cause generally, you would say, I think understandably, as you did, it sure seems like this is over and done. They're not giving them very much time to say anything in the alternative. Um, but some of these are formalities that I think look better than they are. We are closer to the start of winning this case than we are the finish, but we've crossed a very important and rare hurdle at the outset.
I'll take that. I'll take your last one to keep my optimism going. Bob, you're very familiar with the chain of events leading up to the Washington state abolition of the death penalty in 2023. The situation in California today, right now, is very similar, isn't it? The Washington Supreme Court found the state's death penalty scheme unconstitutional because of racial bias in 2018. 5 years later, Governor Jay Inslee abolished the state's death penalty statute. Can you compare the two situations, and I'm especially interested in whether Governor Newsom could use the Supreme Court ruling, if the death penalty is found unconstitutional, to commute the approximately 573 death sentences in California, or will the court do that for him?
Thanks, Mary Kate. You've raised a couple of different points here. You're right that the litigation in the Washington Supreme Court is one of the models that we are working with, where on a similar kind of record of racial bias, the Washington court held that state's death penalty unconstitutional. They did not send the case down to the Superior Court. They appointed a lawyer as what they call a special master to conduct the factual analysis and report directly to the Supreme Court without going through a lower court. She ended up deciding the case on the papers. She didn't hold a hearing with witnesses testifying in a courtroom. She dealt mostly with highly technical statistical questions about the analysis that the experts applied to the evidence of the cases, and sent very detailed factual findings to the Washington Supreme Court, which led them to unanimously hold that the state death penalty was unconstitutional. Governor Newsom will no longer be in the office by the time this case is finally decided. The important thing is that he doesn't have to wait. He can grant universal clemency today. It's an entirely separate process, even though racial bias is one of the reasons that he has cited in the past and would be one of the very important reasons supporting the grant of universal clemency. Invite everyone to go to the website of the Clemency California campaign, www.clemencyca.org, and add your name, if you haven't already, to those urging Governor Newsom to grant universal clemency, and join us on the steps of the state capitol on Tuesday, June 30th, to bring this message to the public and to the governor and his staff for universal clemency. Now, you're right. If this petition is successful, whoever is governor then would not have to commute any death sentences. They would all go away by virtue of the court's order.
What if we had, say we, well, I won't editorialize, but say we got a Republican governor, would a Republican governor be able to undo a commutation if it came from the previous governor? How would that work?
No. The power to commute death sentences is in whoever is governor at the time. President Trump devoutly wishes that he could undo some commutations and pardons that were issued by President Biden, but he can't. Nothing that the Republican governor could do with a successful total resolution of this case. There's other scenarios that there's things that a governor could or couldn't do, but no. Governor Newsom commutes death sentences. I mean, the district attorneys in a few inland counties could keep asking for new death sentences, and whoever is governor then could either commute them or not, as was their choice. But the commutations that Governor Newsom granted would stand, and those individuals would no longer be under death sentence.
I see. Thank you for that. Jess, it took 5 years after the Washington Supreme Court unanimously ruled that the state's death penalty was unconstitutional before Governor Inslee officially deleted capital punishment from the law. Do you know why it took that long? And do you think it could take Newsom that long? Although now that I'm asking you that question, Newsom wouldn't have 5 years since he's terming out. But can you talk a little bit about the timing on all of this with the Supreme Court decision and the governor's decision?
Muted. Sorry about that. Sure, Mary Kate. Thank you. And thank you for having us here today. So in Washington, the legislature repealed the death penalty statutes as a matter of clearing dead wood after that state's high court found the death penalty unconstitutional in Gregory. But in California, the death penalty statute can only disappear from the books by popular vote. Neither the legislature nor the governor can repeal the death penalty on their own. But if the court grants the relief we seek, the death penalty laws currently enforced may no longer be applied. As Bob mentioned, of course, even though the governor is terming out, he doesn't have to wait. If the governor sees this order to show cause as we do, which is that the California Supreme Court sees merit to our discrimination claims, then the governor has an opportunity to act through universal clemency. I'm not sure why it took the legislature in Washington 5 years to clear the dead wood from the books after Gregory. Bob may have an answer to that. But the process would be significantly different here in California.
Okay.
If I might, something similar has happened in California a couple of times before. The California voters have made serious mistakes before. In 2000, we enacted an initiative statute prohibiting same-sex marriage. The California Supreme Court held that unconstitutional in 2008, and couples began getting married. The law was still there on the books for a few more years, but it couldn't be enforced, and eventually it was repealed. In 1920, the voters adopted something called the Alien Land Law, which said that immigrants from Japan and China could not own agricultural land in California. California Supreme Court held that unconstitutional in 1952. It took several more years before it vanished from the statutes, but in the meantime, it couldn't be enforced. So that's not a serious problem, would not be an impediment if the court ruled in our favor.
So, okay, this isn't as okay. I thought I was more, I think I might have been overly excited about all of this. I'm coming down to earth now. Avi, in 2021, Banta said, the death penalty has long had a disparate impact on defendants of color, especially when the victim is white. A very clear statement. It certainly wouldn't give him wiggle room in his reply. Is that you would agree? I think that that's fair to say that Banta doesn't have a lot of wiggle room.
That's right. I think this is the part where, Mary Kay, we can lift you back up. Um, the the strength of this case, there's a lot of reasons to oppose the death penalty, legal reasons that have been raised in meritorious legal challenges for a long time. They haven't done away with the death penalty in California. What has us with significant momentum this time is a couple of things. One is the strength of the studies, the proof that has been put together from numerous overlapping statewide and county studies, all of which comes to the same conclusion. And also sort of within spitting distance of one another in terms of the ratios that they're finding of disparity. So there's a lot of merit to these studies that are done by leaders in the field. The other piece is, as you mentioned, the opposition has conceded the point before the case began. Not only saying that discrimination in application of the death penalty would be a serious problem, but that it exists. I mean, that's the important part. So where is there wiggle room? I think that's what we're about to find out. But I think, and I certainly don't want to make the case for them, but here's what I would say we might expect. Thinking cynically, as I think we have to do sometimes to be strategically prepared. This is a political hot potato and always has been a political hot potato. and the Office of the Attorney General and the Office of the Governor are political positions. And so the question is, what is the risk to them politically of taking bold action in any direction versus the status quo? I think that's what we're up against. There hasn't been public clamoring of late and clear consensus of late with regard to the death penalty. There has been more public clamoring and consensus around the influence of race in the criminal legal system generally. We've had multiple now iterations of a Racial Justice Act in which the public has said very strongly that they are ashamed of race, not only in the criminal legal system, but in the death penalty in particular. And so, how is the Attorney General going to thread this needle? I think the only opportunity to sort of muddy the waters, not to take a position that there isn't racism in the death penalty, but just to preserve the status quo, which I think may have some political appeal, would be to suggest that there is some daylight between the conclusion that we all agree is there and the particular studies we rely on. And I think the most likely thing that we may see is some sort of prodding of various methodologies or just raising questions, not saying that the conclusion is wrong, not saying that even the methodology is wrong, but just all of this needs to be examined. And that looks like, oh, we're just doing our due diligence. I think that's what we're likely to see, frankly, in some form or another. Whether that means the AG ultimately comes to the conclusion the methodology is in fact rigorous, these studies come to the conclusion that they say that they do, and therefore they make the point that I've already agreed is the ultimate conclusion. I think we have to wait and see. But I think I'm not sure if I'm saying this eloquently, but we have two things going on at the same time that are sort of in tension. One is what he knows to be true. The other is what may or may not be politically expedient. And I think the way that those two merge is we may see some testing of the studies with a suggestion that it's just a search for objectivity, just rigorous fact finding, in accordance with what the Supreme Court has requested by virtue of issuing an order to show cause to the Superior Court, as opposed to just deciding the matter. I think that can be passed off as good governance as opposed to defending the influence of race in the death penalty, if that makes sense.
Yeah, it does make sense. And this question can go to any one of you that would like to talk, all of you. Where do you expect the opposition to come from? And what would be I mean, like I assume you're like there are district attorneys in red states that we can expect opposition. But could you any one of you tell us where will we see opposition to abolishing it or to the argument, I guess?
When I'll pipe up first. When we were in the California Supreme Court while the petition was pending, a couple of district attorneys' offices in Southern California, which is a real death belt, filed pleadings purporting to be parties in the case. That is, they were not sued, they were not invited to participate in the case, but they filed pleadings in the case, just sort of like claiming to be parties, and their arguments were just in opposition to everything that we said. I mean, each point that we made, they opposed. So they certainly have presented opposition in the case thus far, and we are not sure what their level of participation will be moving forward, if they will be amici in the case in the Superior Court as they were ultimately deemed in the California Supreme Court.
And if I remember, at your statistics that you presented in the writ to demonstrate the racism, they were shocking statistics, and they were from those death penalty counties where the Black population was minuscule and the number of death penalty convictions really high, right? I mean, it was undeniable. No?
I agree. I think you're exactly right, Mary Kate.
So it's interesting. I mean, that expression, you can't argue facts. Would this seems to me that it would be a case of arguing facts.
I was just going to say, if I can jump in on this, they're not unrelated, the 2 points. That these are the counties that want to participate and that these are the counties that have the worst statistics. If you start from the premise that capital punishment is a tool of racial subjugation, it is both most wanted and most practiced in the counties to which that appeals. And so the district's attorneys of these counties use the death penalty a lot because the people of those counties, the popular majority, likes using that tool. And by the same token, they don't want it to disappear. So anytime it's imperiled, those district attorneys pop up and say, no, no, there's some basis for, whatever it may be. They have the most to lose, and they're the actors who are being most directly challenged. And so, I mean, I think everyone recognizes that among the many disparities of the death penalty is a regional disparity. And so I guess what I'm saying is we won't be surprised if we see the same couple of counties that appeared in the California Supreme Court rear their heads here in the Sac Superior Court. Just as we're not surprised when we see these same counties show up, by the way, in any case that makes its way on the death penalty to the California Supreme Court. They are the chief practitioners of capital prosecution. They are its chief defenders. And so whatever the challenge is, we expect that they'll want to be involved.
But Avi, how can they argue a fact? I mean, there's no denying the racism. Like, would they just cop to it?
I do not think that they would cop to it. I think that they would do well, I think there's two ways. One is the sort of methodological challenge, which relies on alternative experts and an attempt to paint our conclusions as unfounded because there are some. I mean, I don't think this will be a fruitful path, but the appearance of scientific rigor. Another is the more blunt appeal, which we see all the time, which is this wasn't racist. Look at this person's offense. The appeals to fear and misunderstanding. The visceral response that has been, I think, the reason that people who don't understand the ways in which the death penalty operates as a tool of subjugation, why do they get behind it? Because they're afraid of bad crimes. And so I think there will be an emphasis on a couple of hand-picked cases to say, these were bad crimes. This has nothing to do with race. We need this tool because it deters for retribution purposes. I mean, these are tired arguments, but I expect that that's what they would raise.
I'm thinking about the California Committee on Revision of the Penal Code, and their report, which was so it was exactly what you found in your writ. Like it was exactly they were decrying the racism and showing the same statistics, the same charts and graphs. And this is a committee that was appointed, the members of whom were appointed by Newsom, by the governor. So I would think that, that would have a lot of weight from the Commission on the Penal Code. Yes, have they entered into the discussion at all at this point?
The commission is not an organization that intervenes in litigation like this. It makes excellent recommendations to the legislature, a substantial number of which the legislature has adopted over the last several years. And we do rely upon the staff research of the commission with their rely on their findings and rely on their credibility, among many other things in the allegations that we're making.
And they do like other state actors and people, stakeholders, folks who are involved in this, have made findings that the death penalty is discriminatorily applied in California.
So, what can you tell those of us who are not lawyers and not as familiar with the legal process? Can you lay out for us where we go from here? Is it just a waiting game? I realize the response from Banta is a week from tomorrow, is due a week from tomorrow. But then will that response from Banta, will that be public or will it be private and sealed in the courts? Like what, can you lay that out for us, what we can expect from here? Any one of you?
I can start. I think we all have some understanding, but also a lot is yet to be determined. What if, first of all, the response will be public. Um, we can all digest it in real time. What it says will be very interesting, and we're, you know, very much anticipating that as well, and that will determine in part what the course of things is. It seems probable, seeing as the California Supreme Court did not finally determine some of the questions that were briefed previously, that some or all of them will reappear. So there are some legal questions that the Attorney General previously raised, suggesting, well, we need to clear these questions out of the way first before we can decide any of the facts, questions about standing and so forth. So some of those questions may reappear. What happens in terms of the underlying facts, the question that you asked me previously, we don't know at this point in terms of the degree to which they may contest, the process they may seek for contesting, what the grounds for that would be, and how it will all look. All of that is uncertain. We will get an opportunity to file a reply, in which case we will rebut their arguments, the legal arguments as we have previously. And respond to whatever it is that they suggest about the facts. That's sort of the most unknown. And then any number of things can happen in the Superior Court. The Superior Court could say, I think the most unlikely, you know what, I'm convinced the death penalty in California is unconstitutional as applied. I think more likely is the court resolves on some timetable some of the preliminary, purely legal questions, and then issues an order that sort of determines the path for making a decision about the facts. That's supposing, for example, that the facts aren't contested. It could be that the court says, I want to see written objections to the studies or questions. It could be that the court says, I want to take evidence through testimony or depositions. In other words, bring in some of these experts and subject them to cross. The court can do something called, appoint a referee or a special master, an expert, and say, look, I'm not a statistician. I would like a statistician to review all of these on my behalf in the first instance. So there's a bunch of different ways that the factual portion of this could go, and some of that depends on what the AG says, and it's ultimately up to the Superior Court. How long any of that will take, it varies widely. A purely paper proceeding, much shorter than one that calls for live testimony. And one that calls for live testimony also can vary a lot in terms of its scope. How many witnesses are we talking about? What opportunities are there for pretrial discovery or deposition? Are we treating the facts that were previously submitted to the Supreme Court as the full universe, or are there going to be additional studies commissioned? So a lot of that is up in the air. But to return to the point that we started with, we view the studies as comprehensive and complete. We see no, and we would contest the need for additional studies. We don't mind subjecting the studies that we've submitted to a probing analysis. We think that they will hold up and that the conclusions are extremely sound. Um, but we would be in favor of limiting the degree to which the facts are completely, reopened. But we don't have total control, and we'll have to see where that goes.
And Mary Kate, something that the public and the media can do is
Yeah.
keep an eye on Mr. Bonta and what he does file in the court and compare it with the statements he's made over over the past few years that you quoted, and by way of letters to the editor or social media or however, keep his feet to the fire, remind him, tell him if it appears that his deputies are making statements that he might not conform to his image as a warrior for racial justice.
That's a great idea, Bob. I like that. So yes, the people, we the people, can do something to support your efforts through that kind of advocacy, editorials, guest editorials, letters to the editor, that kind of thing. And you think that that could be really a significant support? Do you think that we could really make a difference?
Uh, Mr. Bonta is a politician who at some point wants to be the Democratic candidate for governor of California. And when that day comes, his statements and the litigation posture of his deputies on questions about racial justice and questions about criminal justice and questions about the death penalty are and should be fair game for public scrutiny.
Then along those lines, we also have Newsom openly saying that when he announced the moratorium on executions in 2019, he said at the time that it is racially applied, that it is racially discriminatory. So Newsom, of course, is a politician. Um, he has also sort of boxed himself in then, Newsom himself, yes?
We hope so. And the Clemency California campaign is designed to remind him, number one, that he knows that universal clemency is the right thing to do. And number two, the people he cares about will have his back when and if he does it.
Yeah, yeah. Okay, that makes a lot of sense. I guess, yeah. I guess I'm just having trouble wrapping my head around these people who, don't have any wiggle room and that are still wiggling, I guess is kind of my issue here. You think it'd be, yeah, you guys win and, is it the game over? But I guess not, especially with the death penalty.
Mary Kate, that is, I think, the perfect point for the public to make is what are we doing here? Because we can give answers to legally what the AG or the governor or someone might say to, chart a course between their public statements of there's racism and the death penalty, but we don't completely concede all of the petitioner's claims in this case, or we're not ready to, or there needs to be some process. I think the public can ask the common sense question, which is, why are we going through this charade and spending a lot of taxpayer money and taking a lot of time? And in the meantime, by the way, a point that I think that people sometimes miss is moratorium on the death penalty or not, a tremendous amount of resources and a lot of suffering is happening right now with California's death penalty still in place. There are still capital prosecutions ongoing. There are many people, 500 plus, with a death sentence hanging over their heads, only like 100 and change of whom even have attorneys at this point. I mean, the death penalty system is causing a lot of harm right now. And so it's worth saying, what are we treading water for? A moratorium is nice, but it's not far enough. If we're all in agreement that there's racism in the application of the death penalty, what are we doing here? Let's, as political actors, take the proper course and put an end to it. A court has now blessed the legal claim and said there's a lot going on here that needs further investigation. If the political entities on the other side of the V already concede the point, at least in generally speaking, let's end the charade and take appropriate political action to end the case and the death penalty and remove the stain from California's legal system. I think that's a wonderful thing that for the public to put out there, and I hope that people do again and again, because keeping this in the news as this case sort of goes on and winds its way from here to there is critical to maintaining pressure. There's always a risk with a case like this that, it has a couple of inflection points that attract public attention, but then, people escape accountability because the public loses interest or something else happens. So I would very much encourage anyone on this call to do whatever they can to draw attention to the question that you're raising.
Yeah, I think, yeah, definitely. This has given, I think, all of us a lot of to think about in terms of how we really can support this effort. And that's wonderful to know that we do have some say here as voters, as Californians, etc. I do have one more question for you guys, and I don't know if this is a question. I don't know, but could the Superior Court say there's nothing this writ is worthless? No, there's no the death penalty isn't racist. You can throw this out, Supreme Court. Could that happen, or that's not even in the realm of possibility?
Court could deny it on any number of reasons. We think that there are very strong reasons for them not to do that, and the more that the judge looks into the details of the case, the less likely that is. It could be denied. That would be an appealable judgment that could be appealed to the Court of Appeal and beyond that to the Supreme Court. We certainly hope that doesn't happen. It's a possible outcome.
So the Superior Court could say this is not a valid writ and we don't see the racism, but that would not mean the end of the issue. That would not put everything to bed, right?
That would not mean the end of the issue, and it would not make these powerful facts about the race-tainted nature of the death penalty go away. No judge has the power to wave a magic wand and make those real-world facts go away, whatever they're ruling on the law.
Okay, so I'm sorry to belabor this, but I really am a little confused. So if the Superior Court said, sided with no, what would go from there? Jess, you have an opinion.
I do. I think our claims are meritorious, but if the Superior Court decided to the contrary and denied the petition and our applications for relief, then we would appeal the Superior Court's orders and rulings to the Intermediate Appellate Court, the California Court of Criminal Appeals. And then if they decided against us, we would appeal further to the California Supreme Court.
I see. Okay. Wow. So yeah, now I see why Avi was saying that we're at the beginning of the start of the line, not not near the finish. We really are at the beginning.
But I would add one other thing, Mary Kate, which is that um, certainly agree with Bob that the Superior Court can deny the writ, but the Superior Court cannot reverse the order to show cause. In other words, can't disagree that the case should proceed.
Oh.
Can't say that the Attorney General does not need to file a formal response. So we'll need to resolve the legal issues that are going to be raised by the Attorney General and our pleadings at this initial stage. The other thing is a little bit softer, which is um, the California Supreme Court has done a rare thing and issue this order to show cause and directing it back to the Superior Court. I don't care what the predilection of the particular Superior Court judge who grabs this case is, they're going to take that seriously and treat as significant the request to do some real work on the case. And so I don't think we're going to see anything that is casual about a denial of our claims. I think it would only be based on some very rigorous either legal dispute or fact finding with a very sound basis. Just to bring the point home, the Superior Court doesn't have any more to go by than what any of us do in the order to show cause. That's it. There's no
Oh.
there's no private memo from the California Supreme Court to the Superior Court. There's no, you know, informal conversation. They're reading the same tea leaves of that very general order, which seems to have, positive language in it. And so I think the court is going to be going by the tradition of what is an order to show cause and saying, court is asking us to do a sweeping review of these claims and resolve all of them in full conclusively. So I think we're going to get a real process and nothing that's the slightest bit dismissive, and that's out of deference to the California Supreme Court.
Oh, that is wonderful to hear. And then I before I let you guys go, I just have one final question. And it is it significant that the Supreme Court's decision on this, the ruling or the order to Banta was unanimous, or was that to be expected? I just wondered if that gave it extra weight that the California Supreme Court unanimously voted this way.
When the California Supreme Court grants review in a case that's come up through the ladder, the order granting review is invariably signed by all the justices, even if they had disagreed and not all of them had agreed to take the case. I think that we can project that standard practice onto this particular order. The fact that the California Supreme Court had this case for more than 2 years before issuing any kind of order is a strong suggestion that there were internal divisions within the court that took a great deal of time to work out, and we may have seen a compromise decision that was not everyone's first choice, but was something that every justice could live with. That might be quite a reasonable reading of the order that we got after 2 years, which was not the specific order that either side had requested.
Oh, that's interesting. That is a excellent point. That the 2 year deliberation probably did indicate that there was lively discussion on the issue. Okay, well that helps very much. I can't tell you how much I appreciate all three of you being here on behalf of DPF. Um, as I told you, and I know you guys poo-pooed it, but I think you're heroes, and I really believe that, and I on behalf of everyone, I think that's opposed to the death penalty in California. We really thank you for your efforts. It's just you've inspired a lot of us, and I we really all appreciate you very much.
Uh, Opposition to the death penalty is a joint effort between the people who litigate in the courts and the people like you who litigate in the court of public opinion. We need each other. Neither group can do it alone.
Well said, Bob. Thank you. Thank you very much. Thank you all three.
Thank you, Mary Kate.
Yes.
Thank you, Mary Kate.
Bye, everyone.
Bye.